Brother took me to court to claim Dad's $4.7 million estate. The judge sanctioned him instead. My brother Nathan has a tells when he's lying. He did it the first time at age 7, when he blamed me for the broken kitchen window, a baseball, his pitch, my supposed suggestion that he throw it near the house. He did it at 16 when he told our parents he'd spent the weekend at a study group. He did it at 32 when he stood up at our father's funeral and described himself as Dad's closest confidant and business partner, while our father's actual business partner, a man named Roger Chen who had worked alongside Dad for 23 years, sat 3 rows back and stared at the floor. The tell is subtle. Nathan straightens his back slightly, just a millimeter, the posture adjustment of a man reminding himself to perform confidence rather than feel it. He did it the first morning of the trial, when he took his seat at the plaintiff's table and turned to give me a look across the courtroom that was meant to convey certainty. I recognized the tell immediately. I looked away and opened my water bottle and thought about my father. My name is Renata Voss. I'm 38 years old. I'm a licensed estate attorney practicing in Portland, Oregon, a fact that my brother's legal team had apparently not fully considered when they filed their suit, or perhaps had considered and dismissed, which would explain a great deal about the strategy they chose. I have a small firm, for attorneys, 2 paralegals, 1 office manager named Simone who has been with us for 9 years and keeps the entire operation functional through a combination of organizational talent and quiet authority that I genuinely admire. We specialize in estate planning, trust administration, and contested inheritance, the latter of which has made up an increasing portion of my practice over the past decade, as more families discover that grief and money are a combination that reveals character with brutal efficiency. I know how these cases work. I have litigated them from both sides of the aisle. I know exactly what a well-constructed forgery claim looks like, how to walk a handwriting expert through contested documents, how to build a narrative around a dying person's last wishes that makes the court feel the emotional weight of the accusation before the evidence is even examined. I have used these techniques professionally. I understand them completely. My brother and his attorney, a man named Clifford Marsh who is very good and charged accordingly, had constructed exactly that case against me. They were claiming I had forged our father's final will. The estate was valued at $4.7 million. The house in Lake Oswego, the investment portfolio, the business interests my father had retained in a regional manufacturing company he'd co-founded in 1989. The will, the one I had helped my father draft, the one he had signed in front of witnesses and a notary on a Thursday afternoon in September 2 years before he died, divided the estate 60% to me and 40% to Nathan. The will Nathan's team was contesting gave everything to Nathan. The will that didn't exist, that no one had ever seen before my father's death, that had appeared 6 weeks after the funeral in a document box Nathan claimed to have found in our father's home office. I had spent 6 months preparing. My co-counsel was a woman named Patricia Kwan, who had been my father's estate attorney for 18 years and who had, on the Thursday afternoon in September 2 years before his death, sat in the room while my father signed the real will. Patricia is 64. She has short white hair and the calm of someone who has sat with families during the worst versions of themselves for 4 decades and found a way to remain compassionate without becoming naive. We had worked on this case together every week since Nathan filed. We had found things Nathan had not expected us to find because he had underestimated, as he had underestimated me my entire life, the specific capability of someone who does this work every day. I should tell you about my father because Nathan's version of him is not the version I knew, and the difference between those 2 versions is the core of everything that happened in that courtroom. Douglas Voss was a man who had built things. Not dramatically. He was not an empire builder, not a visionary, not a person who appeared in magazines. He was a careful, patient, methodical man who started a small precision manufacturing company at 31 with 2 business partners and spent the next 30 years making it into something durable and reliable that employed, at its peak, 84 people. He was proud of the 84. He mentioned the number regularly. When the company eventually sold its majority interest to a larger firm in 2018, my father retained a significant minority stake specifically because he wanted to stay connected to the people who worked there. He was a private man with a deep internal life that he expressed most clearly through action rather than speech. He paid for Nathan's college tuition without hesitation and Nathan's business school without comment, even though the business school education was never deployed in any obvious way. He paid for my law school in the same manner, without ceremony, in quarterly installments, noting each one in his household accounts under Renata, education, in the same tidy handwriting he used for everything. That handwriting is relevant. I will come back to it. His health deteriorated beginning in his late 70s. Heart disease, managed carefully for a decade, gradually less manageable. He moved more slowly. He tired more easily. He sold the Lake Oswego house and moved to a smaller place, a well-built craftsman on a quiet street, with a garden he could maintain and a home office where he kept his papers with the same orderly precision he'd applied to everything his entire life. In the last 2 years of his life, he called me every Sunday evening. We talked for 30 to 45 minutes. He asked about my cases, which he found interesting in the way that methodical people find precise systems interesting. He liked understanding the structure of how estates worked, the legal architecture beneath the human drama. Asked about his garden, his reading, the small social world of his neighborhood. We talked about Nathan occasionally, with the gentle care of two people who share a difficult subject and have reached, separately, approximately the same conclusion about it. He did not talk about the will. He did not need to. We had drafted it together, carefully, over 2 sessions in the fall 2 years before his death. I had done it professionally, and he had reviewed it with the same methodical attention he gave everything important. He had signed it in front of Patricia and 2 witnesses on a Thursday afternoon in September, and Patricia had filed it with her office and sent him a notarized copy, and that had been that. He died on a Tuesday in March, at home, which was what he had wanted. I found out about Nathan's Discover document 6 weeks later, when the estate attorney who had been managing preliminary probate proceedings called me to tell me that Nathan had appeared with a different will and a different story. I need to tell you about the home office. My father's home office was a room approximately 12 feet by 14, lined on 3 walls with built-in shelving that he had designed himself and contracted a carpenter to build. The shelves held his books, his files, and a collection of objects he found meaningful. Small stones from places he had visited, a compass that had belonged to his father, a framed photograph of the 84 employees taken at the company's 30th anniversary. In the lower right section of the shelving, behind a row of bound reference binders, there was a fireproof document box. Gray metal, combination lock, scratched at one corner from a move in 2009. My father had shown me this box when I turned 25, and he sat me down to explain the structure of his affairs. A conversation he initiated, practical and unsentimental, the conversation of a man who had watched other families fail to have it and decided his family would not. The box contained his original birth certificate, his marriage certificate from 1978, his divorce papers from 1994, property deeds, financial account information, and his executed will. The will Nathan claimed to have found was not in that box. Nathan said he had found it in a different box, a cardboard file box on the top shelf of the closet in the home office, behind some old tax returns. He produced the box as evidence. He produced the document. He had a handwriting expert. Patricia had called me the same evening Nathan's attorney filed, and she had said, in the calm voice she uses when something is both serious and actionable, "He made a mistake, Renata. Several of them, actually. Do you want me to walk you through them?" I said yes. She walked me through them. 2 months before the trial, I drove to my father's house. The estate was in probate limbo pending the litigation. The house was technically sealed for preservation of potential evidence, but the estate's temporary administrator, a neutral attorney appointed by the court, had granted me access for purposes of case preparation, with documentation of everything I removed. I had the paperwork. I had Simone with me as a witness, because Simone is thorough. I stood in the home office for a while before I looked at anything. It was the first time I'd been in the room since before he died. His reading glasses were still on the desk, a detail the temporary administrator had left undisturbed. 2 pens in a ceramic cup, both red. A legal pad with his handwriting on it, a list of some kind, the bottom half of the page blank where he had stopped. I had a specific purpose, the fireproof box. I had the combination which he had given me at 25. I wanted to verify that the original will was still there, because I needed to know whether Nathan had accessed the box before or after my father's death. The will was there, but that was not the only thing I found. Underneath the will, underneath the property deeds and the account information, at the very bottom of the box, a sealed envelope, cream-colored, with my name written on the front in my father's handwriting. His neat, recognizable, lifelong handwriting. The same handwriting that appeared on the legal pad upstairs on the desk. The same handwriting that had appeared in his household accounts under Renata, Education for 3 years in the early 2000s. I sat down on the floor of the home office, which was not a dignified thing to do, and I held the envelope for a while without opening it. Simone sat down on the floor beside me without being asked and did not say anything, which was exactly right. I opened it. It was 2 pages. The first was a letter, handwritten, dated 14 months before his death. The second was a notarized document, not a will, not a codicil, but a separate signed statement, witnessed by Patricia Kwan, attesting that the September will represented his sole and final testamentary intent, that he had executed no other testamentary documents after that date, and that any document purporting to be a later will should be presumed fraudulent and referred to law enforcement. He had known. He had known that Nathan might try something, and he had prepared for it, and he had hidden the preparation where he knew I would find it and Nathan never would, because Nathan had never been shown where the box was. In the letter, he wrote, "I'm sorry to ask this of you. You've always been the one who understood how things actually worked, not just how they appeared. I trust you to follow this through. I also trust you to be kinder to your brother than he has been to you, because that's who you are, not because he deserves it, but because you do." I read the letter twice. Then I folded it carefully and put it back in the envelope. I photographed everything with my phone, each item separately, time-stamped, geotagged. Simone photographed them too, on her phone, as backup. I put the original documents in my briefcase and signed the evidence log. I drove back to Portland in the early evening, the Willamette Valley opening up on both sides of the highway, and I thought about my father. The Sunday phone calls. The tidy handwriting. The 84 employees. The compass that had belonged to his father, still on the shelf. He had died on a Tuesday in March, at home, which was what he wanted. He had also left me everything I needed, hidden where only I could find it, because he had trusted me to look. Back to courtroom 9. Nathan's handwriting expert was a man named Dr. Albright, credentialed, well-prepared, precise. He had spent 45 minutes testifying about the contested will's handwriting, my father's signature, specifically, using enlarged photographs and technical language that translated, in summary, to. The signature on Nathan's document matched my father's known handwriting samples and showed no markers of forgery. He was confident. The courtroom was quiet. Judge Featherstone, a woman in her mid-50s with reading glasses and the particular patience of someone who has heard every variation of family greed, listened carefully, making notes. Nathan's attorney Clifford Marsh conducted the direct examination smoothly, building systematically toward the conclusion he wanted the court to draw, that the will I had filed was the forgery, not the one Nathan had produced. That I, an estate attorney with professional knowledge of these processes, had used that knowledge to manipulate my dying father. He let that settle. Then Patricia stood for cross-examination. She had a quiet manner in court that I had always admired. She does not perform. She asks questions with the patience of someone who already knows the answers and is simply constructing a path for the court to follow. She asked Dr. Albright whether he had examined my father's handwriting samples from the same period as the contested will, specifically, samples from the last 14 months of his life. He had used samples from a broader period, he said. She asked whether he was aware that my father had developed a mild essential tremor in the last year of his life, documented by his neurologist, that produced a slight but measurable change in his fine motor control. Dr. Albright paused. He had not been provided that medical documentation. Patricia nodded and submitted the neurologist's records as Exhibit 14. She asked whether, given the tremor's documented characteristics, the signature on the contested will, which showed none of the tremor markers present in all of my father's authenticated late-period signatures, was consistent with having been signed in the last 2 years of his life. Dr. Albright said he would need to review the new samples. Of course, Patricia said. Take your time. She sat down. The courtroom was very still. I took the stand after the lunch recess. Patricia walked me through the timeline first, the September drafting sessions, the signing appointment, the 2 witnesses, the notarization, the filing with her office. She walked me through my discovery of the fireproof box, the envelope, the letter. She submitted the letter, the notarized attestation statement, and the photographs Simone had taken as supplemental exhibits. Then she submitted the security footage. My father had installed a camera system in his home office in 2019 connected to a cloud storage service. Motion triggered. 30 days of rolling backup. His technology consultant, a young woman named Devi who had set up the system and maintained it, had given Patricia access the week after the contested will appeared. Devi had extracted and preserved the relevant footage before Nathan's team could make any request to access or destroy it. The footage from 6 days after my father's death showed Nathan entering the home office with a cardboard file box under his arm. He set it on the top shelf of the closet. He left. The box he claimed to have found, 3 weeks later, with the will inside it, placed there by Nathan himself, 6 days after my father died, on a date when the estate had not yet been formally secured. Clifford Marsh objected 6 times during the submission of the footage. Judge Featherstone sustained one of them. When I watched Nathan watching the screen, his own image, his own hands setting the box on the shelf, I saw the tell again. The small posture adjustment. The millimeter of added height as he reminded himself to perform something he no longer had the material to perform. He looked at me across the courtroom. I did not look away this time. I held his gaze for exactly long enough that he understood I had seen the tell, that I had always seen it, and then I turned back to the screen. Judge Featherstone took 90 minutes to deliberate before returning. She dismissed the challenge to my father's will with prejudice, finding that the contested document was inconsistent with my father's authenticated late-period signature characteristics and that the security footage established Nathan had placed the cardboard box in the closet prior to his claimed discovery of it. She admitted the full security footage record into evidence and referred the matter to the district attorney's office with a finding of probable cause for fraud and perjury. She awarded sanctions to the defense equal to full legal costs, payable within 45 days. She ordered the estate distribution to proceed according to the September will. She said it all in the measured, unsurprised voice of someone who has seen this before and finds it no less regrettable for that. Clifford Marsh sat very still through the ruling. He is a good attorney. He had been given bad material and had built the best case possible from it, and now he was sitting with the full weight of that outcome in the practiced stillness of a professional who has learned to absorb difficult moments without collapsing them. Nathan left the courtroom quickly, without looking at anyone. I watched him go. I thought about what my father had written. I trust you to be kinder to your brother than he has been to you, because that's who you are, not because he deserves it, but because you do. I was not feeling kind. I was feeling something colder and more precise than kindness, the particular clarity of someone who has followed something all the way to its end and arrived exactly where they knew they would and cannot feel good about that because it was never a good destination, only a necessary one. Patricia put her hand briefly on my arm. Well done, she said. It was the most she ever said. Outside the courtroom, Devi was waiting on the bench in the corridor with her laptop bag across her knees. She had driven up from Portland this morning specifically to be here for the ruling. She is 29, technically gifted, practically indispensable, and has a habit of showing up for things without being asked that I find enormously steadying. Footage held up? She asked. Perfectly, I said. She nodded once, satisfied, and stood. I told you cloud storage was better than local. Local, he deletes it. Cloud, it was already ours. You were right, I said. She smiled. I know. We walked out together through the courthouse lobby into a gray Portland afternoon that smelled of rain on concrete, the low clouds moving fast over the West Hills. Patricia walked with us as far as the parking garage entrance, where she stopped and turned to me. He was a careful man, she said. He thought about everything. I know, I said. He loved you very much. I nodded. The words were true, and they landed somewhere specific, not painlessly. I had known they were true, had known it consistently, had never needed them confirmed. But hearing them from someone who had sat in the room with him, who had watched him sign the September will with the focused deliberateness of a man putting something important in order, made them real in a different way. More specific. More weighted. "Thank you," I said. "For everything. For the 18 years. She squeezed my hand once and walked into the garage. I drove home through the rain. Portland in April is a city that accepts weather without drama, and I find that quality restful after a day like this one. The streets were wet and reflective, the traffic patient, the radio playing something low and unhurried that I didn't track closely. My phone had notifications I wasn't reading yet. At home I made tea and sat in the kitchen and read my father's letter again. I had read it perhaps 30 times since finding it on the floor of the home office, Simone beside me, the afternoon light coming through the west-facing window. I knew every line, but I still read it slowly, as though it was the first time, because the first time is the closest you can get to hearing a person's voice, and his voice was what I was looking for underneath the words. He had known what Nathan would do. He had prepared for it quietly, with the same methodical patience he brought to everything that mattered, and he had trusted me to find the preparation and use it correctly. That trust was not incidental. It was the last specific, deliberate act of a man who had spent 38 years watching me and had reached a conclusion about what I was capable of. I thought about the 84 employees. I thought about the compass on the shelf, his father's compass, which would come to me now under the terms of the September will. I thought about Nathan leaving the courtroom without looking at me, that quick, efficient exit, and what it cost him to be seen, really seen on camera, undeniably doing what he had done. I did not feel sorry for Nathan in the way you feel sorry for someone who has suffered unjustly. I felt something more complicated. The sorrow that exists when you watch a person make themselves into something diminished and understand that they made that choice incrementally over years and now live completely inside it. He had needed the money less than he had needed to win. I understood that. In our family, winning had always been the currency that mattered most to Nathan, because he had grown up in the shadow of a father who expressed love through the language of competence, and Nathan had always felt slightly beyond the edge of his father's full approval. He had needed to matter most. He had needed the estate to confirm it. My father had seen this clearly and chosen differently. He had chosen precision over peace. He had made a document, filed it secretly, left it where only I would find it. He had trusted me to understand what to do with it and to carry it through without losing myself in the process. I was trying. The letter was 2 pages. The second page was shorter than the first. It ended with a sentence that I had not been able to read without stopping, each of the 30 times I had read it, though for different reasons each time. He wrote, "Whatever happens, I want you to know I saw you. Not the version they made up. You." I sat with that in the kitchen for a while, with the rain on the windows and the tea going cold, and I did not try to resolve it into something comfortable. Some things are not for resolving. They are for carrying. The estate distribution completed 8 weeks later. The house sold to a couple with 2 children who planned to keep the garden, which seemed right. The investment portfolio transferred on schedule. The business interest was handled through a structured buyout that Roger Chen facilitated with the same quiet competence he had brought to 23 years of partnership with my father. The compass came to me in a small wooden box, wrapped in paper by the estate's inventory specialist, labeled in my father's handwriting from the original inventory he'd filed when he moved to the smaller house. I keep it on my desk now. When I'm working on a difficult case, the ones where the family is fractured beyond easy reading, where the grief and the money have become so entangled that separating them requires more patience than any of the principals currently has, I sometimes pick it up and turn it in my hands. It doesn't point anywhere useful from inside an office, but the weight of it is specific and real, and that is enough. Nathan did not contest the distribution. His criminal exposure, once the DA's office reviewed the footage and the forensic handwriting analysis of the contested will, was significant enough that his own attorney had advised him to stay quiet and cooperate with the process. We did not speak. I do not know whether we will. My father had asked me to be kinder than Nathan deserved, and I was trying to honor that in the only way I knew how, by not making it worse, by not pressing every advantage I held, by letting a legal process do what it was built to do, and then stepping back from it. That is not reconciliation. It is not forgiveness in any simple sense. It is something less satisfying and more honest than either of those words, a choice to not become the thing you fought against, even when you won. I learned that from my father. He was a careful man. He thought about everything.